Yeah. Just for the record, once again, Mr. Chair, Corey McCray, Senator for the 45th Legislative District, and I'm here before you to testify on behalf of Senate Bill 82. So Senate Bill 82, Mr. Chair, is a product of conversations that I had with my commanders. I meet with my commanders, my majors, the colonels, lieutenant colonels, every 2 weeks to walk through every homicide and every non-fatal shooting in my district. And there have been products every year that I put forward in reference to learning and loopholes or holes that I do see, and this is one of them. Mr. Chair, when having conversations, one of the things that I found was that Baltimore City is the only jurisdiction that operates where we don't have the system MDEC online. So MDEC is going to come online. It's projected to come online May 6th. But until it does come online, unfortunately, when a person is violated for probation, that is put in the mail. The judges then receive it in the mail, and then they take some level of action. That's an antiquated system in reference to how we're operating in the rest of the world, or the rest of the other jurisdictions are operating in an electronic fashion. I'm not sure why at some point did the judges or whoever say that they would police themselves and figure out a conducive way or efficient way to be able to navigate these different challenges. I pulled up 3 different incidents where a person was violated, the probation officer can say the date that they were violated, and then there's a discrepancy in reference to when the judge actually received it to take action. So while the judges do give testimony, they talked about the 3 incidents that I put forward where there were 2 or 3 weeks delay or a gap in reference to this happening. I'm not here to disagree when the judges received. I'm here to say that when a problem is broken to me, it's my responsibility to acknowledge it. It's my responsibility to do something about it. And Senate Bill 82 is that vehicle. I do have an amendment that I put forward with it and basically said that Senate Bill 82 is null and void if the MDEC system does come online May 6th. So if it does come online, I do think that we're going to be moving in a more efficient and effective way. But if it doesn't come online, like technology with everything, just because somebody says a date when something is going to happen, we cannot sit still if nothing doesn't happen. We now have a responsibility to do something now that we know that there's a gap from that piece of it. The judges acknowledged that from a constitutional standpoint, this will be put on one court. I just wanted to repeat, Baltimore City is the only outlier. We're the only ones operating under USPS versus electronic system. I'm not sure why they just didn't send emails at some point, but like we can't operate in this antiquated manner from that standpoint. The judges also acknowledged that under the several instances that I put forward, there were at least 1 or 2 in reference to the delay when the warrant was served, when these folks were actually pulled off of the streets. That's not the problem that I'm bringing to us. At the end of the day, we know the challenges. A person may not be staying in the same home, and maybe like once the warrant is there, the police have a job to do. But like that's not what I'm bringing before you. So I would just ask you to kind of, you can see it, but like that shouldn't hold in reference to the argument that I'm making that we have to operate in a more efficient way. I'll stop right there, see if folks may have any questions for me, but I would hope that we could move forward with the amended version of Senate Bill 82 that is contingent upon MDEC actually coming online.
Let's hear from the state's attorneys. Ms. Lipscomb first, and then we'll switch back to questions for both the sponsor and Ms. Lipscomb.
Thank you so much. My name is Lauren Lipscomb. I am with the Office of the State's Attorney for Baltimore City. Thank you, Mr. Chairman, for having me here today, as well as you, as Mr. Vice Chair Wallstreicher. Thank you so much for permitting my testimony today. And thank you, Senator McCray, for introducing this important piece of legislation, which will aid greatly in our ability as prosecutors to hold violent repeat offenders accountable. And in any given week in Baltimore City, there are dozens of criminal cases set in for trial. The vast majority of cases resolved by way of a plea agreement wherein an offender is sentenced to some form of a sentence with a period of probation. When an individual is placed on probation, they enter into a contract of sorts between the sentencing judge and the offender. The Department of Public Safety and Correctional Services, DPSCS, operates as the eyes and ears of the court to supervise offenders out on the street. Too often we have a delay through nobody's fault, but too often we have a delay between when a VOP warrant is requested and any action being taken by the court. This is a public safety concern, As an example, I also brought in a case that's actually pending right now, part of the public record. An individual was on probation for firearm possession, being a felon in possession of a firearm, as well as possession with intent to distribute cocaine. That individual went out and violated their probation by way of never showing up to report to DPSCS. As such, a request for warrant was issued by DPSCS, and that request was issued on October 12th, 2021. As of August 30th, 2022, no action had been taken on that warrant request. And the agency had to again submit an additional warrant request for this offender. And in the new request, they added that at that point, the offender had then been picked up on firearm charges and charged federally. I thank you very much for your time, and we are looking forward to a favorable report on this important piece of legislation. Thank you.
Thank you very much, Ms. Lipscomb. I saw Senator West first and then Senator Carter. Senator West.
Sure.
I'm happy to have Senator Carter go first. Okay, the conundrum here seems to be that the Senator McCray would like the bill to be null and void if the MDEC system goes into effect in Baltimore City as planned on May 6th. But the bill is an emergency bill, which would take effect immediately. And we could have a situation where a new system gets implemented for weeks and then disappears on May 6th. Would you be amenable to our passing this, but not as emergency? So it would take effect on July 1st, and it wouldn't take effect at all if MDEC went in effect by May 6th
I
or
think that's
before
the best way
July
to do
1st.
it. Yep.
Thank you.
Thank you so much, Mr. Chair. I just have a few questions, and actually from the testimony, I realized I might have been a little confused about the bill. I thought the bill, when I looked at it before the hearing, simply gave a requirement that judges would issue a warrant within 7 days of receiving a notice. Is that correct?
They would, yes.
But what your testimony was indicating, it was more of a problem in terms of the length of time it took the judge to receive the notice.
I think that a couple things, Senator Carter. I think that hopefully that this will bring greater coordination. So obviously there's something that's not happening between the courts and the judges in reference to when they're receiving the bill. So I can't refute if the chief judge or whatever judge say, hey, I got it this point in time. I think that they need to figure out a process where it's easy with the electronic to say when you actually got it. And you can trust the credibility and the validity of you actually receiving it at that point in time. But I would like some level of action to take place, because what I've seen is that 2 or 3 weeks have gone by where there wasn't.
The 2 or 3 weeks from the time a violation of probation has been sent out and then the court receives it?
Yes.
So it's not, so my question is, it's not that the judges are delaying taking action, it's that there's a delay in their receipt of it.
I would say that we also need to look at when are they acknowledging receipt, Senator Carter. We don't know, like all we're doing is taking somebody's word for it. So like I will hope that they are receiving it at a point in time, but we don't know that they're receiving it.
Let me tell you something. I love my city and my court system, but I'll tell you as an attorney, as Baltimore City being the only jurisdiction that doesn't yet have the MDEC, this has happened to me a couple of times. I've literally filed a motion with the clerk's office, and the judge has ruled on the motion, granted the motion. And then about a week or 2 later, I get something back from the clerk's office saying my filing was rejected because of a technical problem. So there is a problem with the clerk's office and the courts. But I'm going to get more to my more substantive questions. First, I wanted to understand the bill, because also in my experience, I'm not familiar with judges waiting to issue a warrant when they're asked to issue a warrant. But it often takes quite some time for the warrants to be executed. So in terms of the people, like the judge can issue the warrant immediately, but if it takes a long time for the warrant to be served, which happens quite a bit, that's the problem, or more of a problem, would you say?
I wouldn't say that. I think that this is the problem that I'm bringing forth. And the judges tried to make that same argument in their testimony from that piece of it. Can I lean in a little bit?
It's true, though. I mean,
that's a problem. We can't ignore the problem that we're bringing right here, because I think that this is one that can be dealt with at this moment. So the thing that I would pick up is you said that when they are receiving it, sometimes a judge may take a leave of absence. Sometimes a judge may go on vacation. Sometimes a judge may be serving military duty. What happens is that there's supposed to be a judge on duty that then picks that problem up. I'm not sold that that's always what's taking place, Senator Carter. But that's not on me. I'm laying the issue at you all, and hopefully that you all will have the robust debate. But that's one of the things that I think is possibly one of the issues. So when you say that the judge gets it immediately and then they're taking action, there are different opportunities isn't the right word, but there are different ways where somebody may be missing at that job at that moment, and I'm not sure that the next step is also being taken of the judge on duty being able to take over at that moment.
Thank you. Just a couple more questions. So I don't want to get lost in the other ones that I wanted to answer to make sure I understood.
And the state's attorney sounded like they wanted to comment on that one.
They can, but if I don't mind, whenever I wait and give deference to other people to get my questions out, then I wind up finishing the hearing. I don't get a chance to finish. So, and I think these questions are important. It's my understanding, and this is a good thing if I'm correct, that the bill does not in any way take away the discretion of a judge to make a decision of whether or not to issue a warrant.
Not at all.
And it applies to both people on probation as well as on pretrial supervision. Is that correct?
Yeah.
So it's defendant would be on pretrial, but a probationer would be on probation. I'm not sure if it was clear, but I know that's the goal, correct?
The probation was the part that I was focused on. Like,
Okay, so it doesn't affect pretrial.
not to my knowledge, like how my intent was in reference to probation, because that was the issue that I had in front of me. What happens is I was I'm sympathetic to the issue that the people that have involved in these non-fatal shootings sometimes do have warrants, they don't have warrants. So somebody that may have done the shooting and how long they're spending time on the street. I want to say that the one piece that you asked me about the time frame in which the police takes the person off the street, some of those things are out of our control. This one is in our control. So if a person is not at that house that the police may have looked for when they tried to serve the warrant, if they knocked on or tried to serve it 3 or 4 times, those things aren't in our control. This one right here is right here in front of us and within our grasp.
Thank you. And then finally, I think that if you are talking about probation and the probationer is on probation to a specific judge, it's been my experience that the judge, upon receiving the information of a violation, should they make a decision to issue a warrant, it's a bench warrant, which are generally handled pretty seriously, such that the judge can then make a decision as to whether the person will be held without bail until the next availability that judge has to review it for a violation of probation, or they can make a decision if it's a low level thing to issue like a bond, the person can't be released without the bond. So it's different. Technically, it's different than an arrest warrant. Okay, well, that's it.
No problem.
The state's attorney, you wanted to say something?
I just wanted to lend some information if it is of help at all. I actually oversee the conviction integrity unit within the office, and my folks are the prosecutors who staff the collateral dockets. And I've been in this function in some capacity at some level as a supervisor since 2015. And I can say that my folks handle anywhere from 30 to 60 cases of violation of probations every single week. And so I certainly do have quite a familiarity when it comes to probation and sort of some of these mechanics in terms of what we see. And so I think that Senator Carter, you hit on a couple of different areas in the process, which could, perhaps improve, I think, in terms of our ability to really make sure that we are that public safety remains sort of paramount, because we are in a situation where this is post-trial. So yes, in terms of answering your question related to whether it was pre-trial or post-trial, we are definitely post-trial, post-sentencing, and we're now in the phase where an individual is actually being supervised by the court. Of course, obviously, a sentencing judge is not going to be personally supervising any individual. That's what DPSCS is there to do. But the example that I provided during my testimony, the reason I selected that particular instance is because that was an example of a gap where a request for warrant went out for this individual in 2021, as in DPSCS filed their 42B form to the court, and there was no response one way or the other for a year and a month. And so, who knows what happened, and that's not really the purpose of my testimony is not to do anything but to suggest that there's room for improvement. And certainly from our office's perspective, we had a situation in that case where an individual went out and was carrying handguns again in Baltimore City, which is an obvious problem. And so I just wanted to kind of lend that information if it somehow assists as well. I would just point out that the two options are for a violation of probation to be docketed and then a summons be issued, or a warrant goes out in response to that 42B form. And yes, as the legislation is crafted, that the judge would absolutely retain discretion as to what action to take. It's just really asking that the judge go ahead and take an action within 7 days of getting that request.
So it's really a suggestion, like what happens if it doesn't happen? If the judge doesn't do it, then what? They get off the bench? No. I'm certain you're not suggesting that, but
No, of course.
okay.
Like,
No.
this isn't like, you're not going to sue the judiciary. At the end of the day, there's a problem that exists. There's a loophole. You talked about it from that standpoint. MDEC may course correct and shift gears from that. But right now, if we leave it the way it is, we're jeopardizing the public safety of our city because we're the only ones that operate in this fashion.
Thank you.
Yes, ma'am.
Thank you, Mr. Chairman. Just real quick, and this may be a better, I don't know if Judge Karen might be a better one to answer this, ma'am. On the MDEC system that's in place, is there anything that requires, once it is digitally received, that a judge sign off on that request for a warrant or take action on it within 7 days?
There is not, and if you asking me, I don't know, Mr. Chair, if you want me to answer now or.
Oh, yeah, we want.
Go ahead and answer this, but then we'll just
So the reason I'm asking,
wait,
ma'am,
so you can go ahead and after you answer answers, then we'll roll to our testimony.
please. Oh, I'm sorry, I didn't realize she hadn't testified. I apologize. So if you could just answer that question, ma'am, and then we'll do your.
So the
Is that
answer
okay?
is no.
Okay, so would you have any issues, because I'm familiar with the problem you're asking about, but in this specific language it's here, and then it wouldn't even that my colleague brought up from Baltimore County about if you get on MDEC that it kind of solves the problem, because it really doesn't. It doesn't solve the problem, because the problem is that there's no action being taken potentially. The only thing that MDEC would solve is that there's a digital receipt that they got it. It doesn't require or continue that provision of within 7 days of that receipt that there has to be an action taken, because as I understand, there are some issues within Baltimore City's court system that there sometimes is a significant turnaround time, especially on the one you provided, where there was no action taken. There's a long turnaround time, and we have someone that was a felon with a gun, and there's another offense that occurs and they get taken into federal jurisdiction. So my understanding would be that I would keep the language of the 7 days the same, even with the implementation of MDEC, but have where it says a receipt of written or electronic charges, written charges or electronically filed charges filed under oath. That would be my recommendation. And if you still want to continue as an emergency measure, then you're not doing it for a few weeks. It is implemented, and then in perpetuity beyond that.
So I'm gonna make a comment because I didn't get to dig into Senator West's point. So this was drafted and it was emergency because I do feel as though it was an emergency, but my style of leadership is also speaking with the agencies that's impacted. So we did caucus with the courts to be able to better understand. And that's why you saw the amendment come after the bill is saying that this is contingent upon the MDEC. The 3 incidents that I'd had, obviously there were gaps within them, but there was a discrepancy in reference to when Department of Public Safety said that they received it and when they said that they received it. And then the 3 instances they did cover it within a 72-hour time frame. So like some type of action was taken when they said, hey, we got it this one. And I had one of those in there where Department of Public Safety had to do it twice. So one of them was where they was like, look, I don't know what happened to it, never gets there. It's like vanished. And like, then all of a sudden you had, and what that does is it causes more time. And it's a person on the streets is a threat. I don't have a problem, but I do think that if we move in that posture where we still move to it, if it does have 7 days, that I think that we have to do that as a statewide bill. I was trying to solve a Baltimore City problem. And that's why I was thinking about the MDEC piece. But I do think that if you do move in that posture, it's better to look at it as a statewide versus.
Yeah, and that's, I just wanted to ask if that was something to be considered, but that's,
yes, sir.
I appreciate it. Thank you.
Yes, sir.
Yeah, all right, so we'll hear from the chief judge, but after the chief judge concludes her testimony, I would like you to weigh in on that prospect of a statewide bill. All 24 jurisdictions up on MDEC. The floor is yours. Welcome.
Okay, well, good afternoon, Mr. Chair and Mr. Vice Chair, members of the committee. My name is Audrey Carrion, and I am the administrative judge of the Circuit Court of Baltimore City. We appreciate Senator McCray. He knows that. He's a friend of ours. We've worked on many different issues here in Baltimore City. However, the Maryland judiciary does oppose Senate Bill 82. The bill presents significant constitutional and equal protection concerns as it creates different substantive rules for judges in only one jurisdiction and is especially problematic for the district court, which is a statewide court. These concerns have been addressed with Senator McCray to also include the timely receipt of notification about a violation, which will be addressed when MDEC begins in May of 2024. We are aware of Senator McCray's amendment and confident that MDEC will be in Baltimore City in 2024. But let me go back to the bill. The proposed 7-day response is also impracticable, given numerous factors that may impact the judicial determination as to whether a bench warrant should be issued. Judges don't always issue bench warrants on alleged violation of probations. They look at the original charge, look at what the new charge on probation is. Is it in another jurisdiction? Is it in a federal jurisdiction? That may have an impact on the timeline for response. If the judge is unavailable due to trial, sickness, retirement, or leave, it may have an impact on the timeliness. Violations of probations are generally sent to the judge who has the probation. They aren't transferred to other judges because the judge who placed the probationer on probation is familiar with the case. Further, the language of the bill states that a judge shall respond to a request for an arrest warrant. Respond how? Respond to whom? Is sending an email to the agent requesting clarification in a report a response? Is asking my law clerk to get me the file that's in the clerk's office a response? And I agree with Senator Carter's comment. What happens if this is not responded to within 7 days? Does the violation of probation get dismissed? Does it then become an automatic detainer? That does not seem fair to me. In each of the examples that were provided that Senator McCray provided to the judiciary, it was shown that not only did the assigned judge respond in a prompt and timely fashion, but in several instances, the warrants were still outstanding and or it took many months to have it served. In one of those examples, one of the most egregious ones, there was a warrant outstanding. The individual was shot, was in the hospital, and no one served a warrant while he was in the hospital. Now, I am not familiar with the case without name or case number that the state attorney has presented, so I cannot comment to that. But what I do say, and in listening to those comments, is that there is an acknowledgement that this court of 35 judges hears 30 to 60 cases every single week. And we only have 4 examples, and I'm taking one of them without even having looked at it, of judges who allegedly had not done what they were supposed to do. Finally, the bill pertains to arrest warrants, but violation of probation reports from the Department of Public Safety and Correctional Services, parole and probation, result in bench warrants, not arrest warrants, and that is a clear distinction. In summary and respectfully, the judiciary strongly opposes this legislation, and I thank you for the opportunity to testify.
Thank you, Judge. Questions from the committee? All right, seeing none, thank you very much. And with that, that'll conclude the testimony in the hearing for Senate Bill 82. Thank you, Senator McCray. All right, we'll now move on to Senator Carter. Senator Carter, you ready? All right, we can skip over. Sure, it's up to you. You sure? Okay. We're now up with Senator Carter with Senate Bill 34.
Good afternoon, members of the Senate Judicial Proceedings Committee. It's always a pleasure to present before you standing in this spot, and especially since I believe we are one of the most thoughtful, insightful, and intelligent committees in the entire Maryland General Assembly. And to attest to that is the fact that the bill I'm about to present, we've actually passed about 3 times, and so has the entire Senate. So Senate Bill 34, I believe, speaks to who we are as a state and who we are as people. It involves whether or not we are going to discriminate against only one group of people when it comes to serving on a jury. Only one group of people, because through the process of voir dire that happened at the beginning of every jury trial, civil or criminal, the lawyers have an opportunity to weed out potential jurors for bias or other things, other reasons that they are not fit to serve on a particular jury. So to discriminate against people, only one group of people, people that have prior criminal records, prior criminal convictions, is fundamentally unfair, and it's discriminatory. More than, I think it's 22 other states now have already passed a law or revised a law and no longer exclude people with felony convictions to serve on juries. But in Maryland, we discriminate against both people with misdemeanor and felony convictions because our bar is if a sentence was more than a year and a person served more than a year. A year is a pretty low bar. As you all know, certain driving offenses potentially are more than a year. Certain other boating offenses are more than a year. And so it's too broad a brush. Now, there's no empirical data that would indicate that a person has a bias one way or the other with respect to the mere fact that they have a conviction or have served a sentence. In fact, data suggests that persons don't have a bias. They are just as objective as anybody else and as neutral. And if someone has something to contradict that, I'd love to see it, because I've seen research, and I'm happy to share it with anybody that's interested, that indicates that studies have shown that there's no inherent bias one way or another from someone just because they've served a sentence or been convicted. I can tell you from my own personal experience, whenever I talk to people that I know have had encounters with the criminal justice system or convictions, and I ask them the question, if you were to serve, would you want to serve on the jury if we allowed you to? And they say yes. And I'll explain a little bit more about that in a minute. But I also say, do you think that you'll be biased one way or another about the criminal defendant, having been one yourself? And they say no. But I have had a couple people say if they had a bias, it would probably favor inure to the detriment of the defendant, because having been through the system themselves, if they believe someone else has done an offense, they would want that person to also go through the system too. But all of that being said, when we continue to condemn people based on a crime that they have paid their debt to society for, it speaks more about who we are than who they are. Because ostensibly, we believe in redemption, we believe in rehabilitation. We have now passed a myriad of laws that allow people, even with these criminal convictions, to expunge them. And so I would posit to this committee that we don't know sometimes, even if someone did have a criminal conviction, if we've allowed them to expunge it under the law. So really, we're just harming the people that didn't have the wherewithal maybe to expunge their conviction. I think that what's really important is that we don't want to be a state that discriminates against people because they have a criminal conviction. And it is discrimination because, as I've pointed out in the previous years, there's no other group of people that we just give a categoric exclusion to. We allow people that have been civilly liable, negligent, to serve on civil trials. We allow people that have been victims and perpetrators in auto accidents to serve on a civil jury. And so even if there were an argument, which there is no legitimate one, that a person due to a criminal conviction couldn't serve on a criminal jury, I don't understand why there could ever be a reason to bar that person from a civil jury. I think it's important that we pass this law because I believe not only is it in the interest of Maryland to end this discrimination, but surveys have shown that people that get called for jury service that do serve believe that it's their civic duty and it's part of being a good citizen. And so we know that one of the reasons that people stay on the bottom rung of society, one of the reasons they don't participate fully as a citizen is because they don't believe that they are included. And so by including people, we incentivize them to be better people because we say to them, you are a full citizen and we treat you like everybody else because you've already paid your debt. I think that's critically important. I also believe this is a public safety bill because there have been cases and stories of where cases were either postponed or the fact that there weren't enough jurors in a jury pool, it led to the detriment of a case or it couldn't be tried, it couldn't be resolved. And I have an article here. You all may not be familiar, but I've come across these people when I go to court sometimes in Baltimore. There's a news outlet called Baltimore Witness, and they literally come into court and report everything that happens in there. And sometimes it's not even, I don't even like it because I'm like, dag, did you really have to say that? But basically, and I'm happy to share this, but I didn't print it out for everyone or send it, but I can send it. Since September 1, 4 homicide trials and 2 attempted murder trials has either been delayed or rescheduled due to a lack of jurors available for selection, including 4 cases in September and 1 case in August and another in November. They also go on to write that you generally need about 50 jurors who qualify and who you can pick even before you start. And sometimes we don't have them. And so by expanding the potential pool of potential jurors, you could possibly help alleviate that problem. I also think that our constituents would be happy because some of us get called to jury service over and over and over repeatedly, while others never get called. And so there's also an article that came out last year when I put this bill in, and we passed this bill by the Baltimore Banner. And the Baltimore Banner, if I can find the article, spoke about the very limited number of people in Baltimore City that can be called for jury service, and the fact that more than 1/3 of those called don't bother to show up. And so that also hurts the jury pool. So we could expand it by allowing more people the opportunity to come. Finally, and I don't want to be too long, and I'm speaking from the heart. You've got my written testimony from like the past 3 years. I've said all of this before. We've argued this bill on the floor. The bill in its current form is as amended. by a senator on the floor like 3 years ago. So it does exclude a small category of people, witness intimidators and the like, jury intimidators, I believe, the same bill that we passed before. I cannot stress enough that as we move down this line of accepting that once a debt is paid to society, a person should be restored to full citizenship. We've allowed everyone to vote that has paid their debt, that has served their sentence and has nothing pending, completed a sentence in parole or probation. We allow these convictions, many of them now, to be expunged after a certain amount of time. This is the only remaining category that we still say to people, we don't care what you've done with your life. You will never be a full citizen. You will never be welcome in the courthouse as anything other than a criminal defendant. We don't want you here. It's up to the attorneys and the court to make a decision based on the answers in a voir dire process as to whether or not someone is unfit to serve on a jury. That is not and should not be our decision. With that, I'll take any questions. Thank you.
Excellent. Well said and put. Senator West.
Thank you, Mr. Chair. So last year, I voted in favor of this bill. It came onto the floor and it got a fair amount of opposition on the floor. It ultimately passed, but there were members on both sides of the aisle who voted against it. And in part, I think it may be because there were two suggested amendments on the floor, both of which went down to defeat. So the bill itself contains a number of exceptions, as you mentioned. One is perjury. You're not allowed to serve on a jury if you were convicted of committing perjury. Second is witness intimidation. The third is jury intimidation. And the fourth is a crime under Title 8 of the criminal law article, which relates to fraud and related crimes. So if you've been convicted of fraud, you can't serve on a jury in the future. It shows that basically you don't respect your morals are sufficiently suspect. We don't want you on a jury. Okay, if you've been convicted of committing fraud, for example. So there were a couple of exceptions on the floor. Let me ask you whether or not you would accept amendments to your bill that would add these as additional exceptions. There were only two amendments. First of them would be bribing a public official or a juror. If somebody's been convicted of bribing a public official or a juror, do you think that person ought to be qualified to sit on a jury in the future at any time?
So that's two questions. One, would I accept an amendment? And two, do I believe that it should be included?
Okay, would you
I do
accept
not
an
believe it should be
amendment?
included because I don't think that we should exclude based on the offense that's already been addressed. I think that there are a lot of people that are liars, cheats, thieves, bribers, people who commit fraud, who are never through the criminal justice system, and they can serve on a jury. But in the answer to your question, I think it's more important at this point to expand this pool. And I initially thought I still think we should do the broad brush and say, you know what? A criminal conviction, once a sentence is served, does not exclude anyone. Let the court decide in voir dire. But given the difficulty that this body seems to have with accepting that, even though we didn't, for example, say, hey, you can vote except if you were convicted of murder, you can vote except if you were convicted of rape or bribery or fraud. I think that I would accept amendments because it is more important at this point to stop excluding everybody than it is to have the perfect bill. So the answer is yes, although I don't believe it's necessary.
Okay. Great.
Long answer to your question.
All right. Well, it was a good answer. Thank you so much.
Thanks.
Additional questions for Senator Carter? Excellent. Thank you very much, Senator. We'll bring up your panel if you like.
Thank you.
Ms. DeFore, and I know Ms. Warnken is here. Ms. Califani. And then we'll hear from Ms. Haven, who's joining us virtually at the tail end of this panel.
Good afternoon, Chairman Smith, Vice Chairman Wallstreicher, members of the committee. My name is Christine Dufour, and I'm here in my capacity as a member of the Executive Committee of the Maryland Criminal Defense Attorneys Association, which is a professional organization that has over 450 members from across all walks of the state of Maryland. I'm here in support and urge a favorable report on Senate Bill 34, and I thank Senator Carter for bringing it back again. I just picked a jury with my colleague Andy Jezik last Wednesday in Talbot County. My client was accused of a misdemeanor sexual offense, but he had a prior conviction for rape from 20 years ago, rape in the first degree. I bring that up only to say it was on the record, but two, we had an extensive voir dire process despite us only having 4 strikes on each side because we were litigating a misdemeanor. We had a robust voir dire that lasted hours, and anybody who was a previous victim of a crime, convicted of a crime, was brought up to the bench, asked numerous questions. People who could not be fair and impartial because my client had a prior conviction. 38 out of the 67 potential jurors answered that question. The court exercised its discretion to strike for cause over and over and over again. We did have 4 jurors who were seated who came around on that question and said they could be fair and impartial. The process played out, and I don't see why expanding the juror pool in both a civil case and a criminal case would not let the process play out. If someone has a prior conviction and can't be fair and impartial, he's going to be asked whether or not he could be fair and impartial, whether or not he was treated fairly by the prosecution in his case or by the police. So I believe this is a very good bill. I think the senator is smart to say that she'd be open to Senator West's particular offense of bribing a juror. But I would urge a favorable report. Finally, hopefully it'll be this year that it passes both chambers.
Take questions at the end of the panel. Thank you, Mr. DeFore.
Good afternoon. My name is Natasha Calfany. I'm the Acting Assistant Director of Government Relations for the Office of the Public Defender. And I am here requesting that this committee issue a favorable report for SB 34. The OPD fights for fairness, dignity, and justice for all people, but specifically for people of color and indigent people. Disqualifying formerly incarcerated people from juries perpetuates the racial disparities that are often experienced in our criminal legal system. Black and brown people are disproportionately represented in the legal system. By excluding from jury voir dires the very population that is disproportionately targeted, arrested, charged, tried, and convicted from serving on a jury, it only maintains the underrepresentation of Black and brown people on juries, and it continues to allow for the bias that we often see when we do not have diverse juries. What is that bias, you may ask? Social science research has shown a tendency of white jurors to vote for a conviction of a Black defendant in instances where a white defendant would be acquitted. While white jurors are also more likely to impose harsher penalties on Black defendants. We see that those issues are drastically reduced when jurors are mixed population. Lastly, I would be remiss to not point out the hypocrisy of disqualifying formerly incarcerated people. Our system continues to rely on incarceration as the only response to criminal activity and the only means to accountability and reform. Yet we use that same tool of incarceration to prevent people from completely reintegrating into our society, including jury duty. So I would ask a favorable report, as a jury of our peers is a constitutional right that we must uphold and maintain. Thank you.
Good afternoon, members of the committee. My name is Heather Warnken. I serve as the Executive Director at the Center for Criminal Justice Reform at the University of Baltimore School of Law, and I am here to express our Law School Center's strong support for SB 34. Access to a trial by jury of one's peers is a fundamental tenet of the American legal system. Yet in Maryland, especially for Black residents accused of crimes, this is simply not a reality. The statistics on jury exclusion are alarming. Across the country, approximately 1/3 of Black men have a past felony conviction. Thus, due to laws in numerous states, many Black jurors are excluded by law from ever entering the jury pool. Maryland takes this even further, having both the highest overrepresentation of Black residents incarcerated combined with one of the most restrictive jury exclusion statutes in the country. Maryland is one of, as we've heard, only a small handful of states which excludes people from jury service for both felonies and misdemeanors, punishable by incarceration of a year or more. So SB 34 would remove this outdated and highly problematic barrier, allowing for greater diversity of our jury pools and the reenfranchisement of people with past convictions who have paid their debt to society. So allowing for greater participation in this important civic duty is not only fair, it's more effective in advancing efficiency and legitimacy of our justice system, demonstrated by research in our written testimony and in the Prison Policy Initiative's recent report on this subject. As we heard earlier, we have a serious challenge of legitimacy in our system. So anything that enhances that efficiency and legitimacy is urgently needed. For these reasons, we urge a favorable report. Thank you.
Excellent. Thank you very much. We have one more guest just to join from virtually. Senator Carter, do you want to say something? Okay.
This is so early in session. I think some people that might have wanted to support didn't get up on it. So I did receive communication from Maryland Association of Justice today, who didn't submit testimony. They did last year. They are in favor of the bill. And of course, they represent plaintiffs primarily in civil cases, and also that the bill was supported by the Attorney General. Thank you.
And I support the bill too. I was going to ask about the Maryland's limited voir dire process and how we can change that, which I think will support the efforts under this bill. So I'll have a couple questions. But Ms. Haven, you're up. Welcome. Good to see you.
Good to see you. Good afternoon, Mr. Chair, members of the committee. My name is Kim Haven, and I'm here today in support of SB 34 and to advocate for a crucial change in our legal system. The current practice of automatically disqualifying people with prior convictions from serving on juries perpetuates a system of exclusion and denies individuals the opportunity to fully reintegrate into society and undermines the integrity of the justice system. It is a bad solution to a non-existent problem. Jury service is a fundamental civic duty and a right protected by our Constitution. Denying this right to individuals with past convictions undermines the principles of fairness and equality that our justice system should uphold. It's essential to recognize that having a criminal history does not negate one's ability to contribute impartially to the jury process. The argument that individuals with prior convictions may introduce bias into the jury deliberation lacks any evidence. People with lived experiences in the criminal system bring valuable perspectives that can enhance the fairness and understanding of legal proceedings. Excluding us based on perpetuated stereotypes hinders the potential for a truly impartial jury. Those who have a prior conviction are no more likely to be biased than anyone who's been pulled over for a speeding ticket or who's had a civil judgment entered against them. Every potential juror contributes a unique perspective to a case, as their life experiences have shaped their consciousness and aids them in discerning fact from fiction and probability from possibility. Denying individuals like me the opportunity to serve on juries contradicts the principles of rehabilitation and reentry. If we believe in the concept of rehabilitation, we must extend the opportunity for civic engagement and responsibility to those who have completed their sentence. I urge this committee issue a favorable report on SB 34. This is a crucial piece of legislation. The time is now for us to pass this. Embracing diversity and inclusion in the jury pool not only aligns with the core values of our justice system, but also contributes to a more just and equitable society. Thank you very much. I urge a favorable report.
Thank you very much, Ms. Haven. Good to see you.
to see you.
Questions from the committee? Senator Sidmer.
Just for the sponsor, because I'm hearing the framing of this in the criminal law context. This bill is about service on a jury, and it could be civil or criminal, correct?
Correct.
Okay, thank you
Thank
very
you.
much.
Really quick, I'll be quick. It's just from you mentioned the voir dire process. You kind of missed before you walked through a trial you had. And so Maryland is a limited voir dire state.
Yes.
And can you so the reason why I'm asking these questions is that we have a bill coming up that's going to expand that to obviously allow for attorney-led, a more in-depth process for voir dire. And that supports this bill, the aims of this bill, because there'll be more questioning and introspection for potential jurors. But can you just walk us through what does it mean that Maryland's a limited voir dire state? How does that hamstring you currently? And how does that marry with if you were to expand that, how would that support the efforts of this bill as well?
Well, I would start out first by saying each judge is very different in how they handle the process. So what happens in my jurisdiction typically, and what happened last week, is we have to submit our voir dire questions 2 to 3 days prior to the jury trial. State submits typically a very shorter list than we submit as the defense, especially in a case like mine, where we knew from prior motions practice that my client's prior conviction was coming into evidence. So we knew we had to add additional questions to posit to the jury. But the judge in the end decides to blend the two sets of questions, and the judge decides to say what he might think is duplicitous, what he might think is not relevant. So in the end, we end up, I think of our 40 plus questions, 10 were not utilized. And so we had to make the appropriate objections for the appellate record, which we won't use because it was a good verdict. But in any event, the process is limited in that regard, in that both parties have to submit, but in the end, the court decides, and the only ramification that you have or recourse is to put your objections on the record.
Thank you for that. Senator West.
Thank you, Mr. Chair. Just a follow-up to that. There are two different kinds of challenges which are permitted in both civil and criminal cases. There are challenges for cause, and you talked about the judge a couple of weeks ago or recently who disqualified a lot of people for cause, but then each side also has discretionary challenges.
Yes.
So the voir dire process would continue under this bill as it does now in terms of inquiring of possible jurors, whether or not they might have a bias one way or the other. And then at the end of the day, if the witnesses if the prospective jurors are not disqualified for cause, either the plaintiff side or the defense side, or in the prosecution side or the defense side, would have the opportunity to still exclude various jurors on a discretionary basis. That's correct, isn't it?
Yes, and I can at least speak mostly to this criminal side.
Yeah.
The number of preemptory or strikes that either party, the state or the defense, can make is determined by the level of the crime. So when I indicated, although we had a larger pool because we knew the prior conviction was coming in, it was a misdemeanor offense, the 4th degree sex offense. So there were only 4 strikes on one side, 4 strikes on the other. The bottom line is you know very little about your jury unless they raise their hand and they answer one of those voir dire questions. And some people choose not to. I was in a situation a couple of years ago in Caroline County where jurors sit for 1 month. And we had a client called for one of my jury trials and he raised his hand, can't be fair and impartial. I will always believe the police officer for tester officer, and listed a list of relatives who were police officers. 2 weeks later, he's in my jury pool on another case. And the judge and I look at each other. It was a different prosecutor at the time. And we're like, jury 61 chose not to answer that question. And of course, the judge called him up and said, 2 weeks ago, you answered the question this way. Why aren't you even responding? So we don't know if anybody's responding truthfully or not truthfully. I can tell you the jurors last week, when they came up to the bench and they have to describe they were a victim of a crime, it's moving. And both the state and the defense and the judge get to ask respectful questions and let them answer.
Well, let's posit that the process isn't perfect, but it's, under the circumstances, it's about the best we can do in terms of voir dire, isn't it?
I think it can be improved upon, but when you're questioning prospective jurors and they come up to the bench and they say, I would like to say it can be fair, but I can't. I think this is too much of an obstacle, knowing about a prior record or knowing what my prior victim history is. I think it's a great system to have the ability of a judge to say strike for cause. Now, I think only 2 out of our tens of questions to strike for cause were denied. And then, of course, that's when the parties get to use their peremptory strikes.
Right.
But by and large, the judge in a situation like that, when the jurors are being quite candid and all parties agree, there was no problem with striking for cause.
Okay, great, thank you.
Seeing no further questions, thank you all very much. This is
Thank
great.
you. It's good to see you.
Yeah, good to see you likewise. All right, so that will conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel and we'll hear from State's Attorneys Richard Gibson and Stephen Kroll.
Good afternoon, everyone. My pleasure to be here. Rich Gibson, State's Attorney for Howard County, President of the Maryland State's Attorneys Association. I'm here on behalf of our organization. The prosecutors of the state have discussed this bill and opposed this bill. The premise when you're picking a jury is to find 12 neutral individuals, right? 12 individuals who know nothing about the case, nothing about the people involved, their prior experiences. They are not going to allow to invade this magical space where we're discussing the facts, judge the case based solely on what's in front of it, and based upon the rules, the law given to them by the judge. Prior experiences, in particular, having a long period of incarceration, change you, alters the way you view things. That experience is not likely to be ignored. The actual sentence that an individual received is not allowed to be considered, or something that person could be exposed to, not allowed to be considered by the jurors. They're literally not supposed to know that at all. And the problem with this bill is that it would allow individuals who've had this significant impact in their life, sitting in a room and judging cases. I don't know that it's fair to the victims or the defendant, for that matter. If the potential juror took the stance, well, I served my time, so could you? That's a problem. It's a bias. They're not supposed to have that invade this process. If they took the stance, well, I think the incarceration system is terrible and wrong, and no one should be incarcerated. Again, similarly, a bias that invades the question of whether or not this defendant committed the alleged crimes in the courtroom. Much argument was made about a person should not be restrained forever for their offenses. I agree that people should be allowed to be reformed, but Maryland as a state already recognizes and has codified laws that have lasting impacts for criminal choices. The Maryland Sex Offender Registry, commit a sex offense 20, 30, 40 years ago, you have to be on that for life. Handgun violations, you commit a handgun violation, you're disqualified forever from having a handgun, right? If I may, the state would ask for an unfavorable report for Senate Bill 34. We feel that the risk to attaining proper due process for victims, for defendants, is greatly jeopardized when we have individuals that have lengthy records deciding whether or not this individual before them committed a particular crime. In the criminal context, as Senator Sidnor said, because our opposition relates to crime and criminal trials versus civil trials. Steve?
Thank you, Mr. Gibson. I'm Stephen Kroll, the State's Attorney Coordinator for Maryland, and Executive Director of the Maryland State's Attorneys Association, and I've been trying jury trials since 1984. My comments will be directed to felonies, not to misdemeanors, because misdemeanors, both the state and defense get 4 and 4, as Mr. Four pointed out, strikes, equal amount. But in felonies, it's different. Depending on what the felony is, it's either 10 strikes for the defense and 5 strikes for the state, so it's not even. Or from the most serious crimes, it's 20 and 10, 20 strikes for the defense and 10 strikes for the state. So it's not even as it is for misdemeanors. When I've talked to victims and I say to them, we only get 10 strikes, they get 20, or we only get 5 strikes, they get 10. Victims say the same thing over and over. How is that fair to us, meaning the victims? So somebody's convicted of murder can go ahead and sit on a jury, but somebody who's convicted of perjury cannot? How is that fair? And it really isn't fair if you look at it. And for those reasons, we're asking for an unfavorable report as to Senate Bill 34 for fairness to victims and witnesses. Even the playing field where we each get a certain amount of strikes, then it would be fine, especially for felonies where it's uneven from there. I've been in opposition to this bill each time. I'm only arguing Senator Carter as to felonies, not to misdemeanors where it's even 4 and 4. So for those reasons, again, we're asking for an unfavorable report as to Senate Bill 34. We're asking to even the playing field. Thank you.
Thank you. Are there any questions? Yes, sir. Senator McKay.
Chair, this question is for Mr. Gibson. I guess, wouldn't you agree that everyone has inherited biases due to their own life experiences?
Yes, but through the jury process, right? Again, I use the term magical space. When you're picking a jury, what those 12 people are supposed to be able to do, what they're saying and swearing they can do, is that they can leave those experiences behind them and not have them invade this process. You bring your common sense, but your prior experiences, your prior biases, your prior thoughts are not your thoughts about whether the law is appropriate or not are not supposed to invade that jury process. In that room, when you're selected as a juror, your role is to listen to the evidence presented during the course of the trial and decide whether the facts as they're presented, whether they match with the law the judge provides to them, whether they feel the person in a criminal context committed the crime or not, beyond a reasonable doubt. So if someone's had a significant experience that jars them, let's say they were a victim of a rape, and this is a rape trial, right? And we're asking that juror questions, just there's a voir dire process. The ultimate issue is, can you put aside the fact that you were raped and sit and judge this person who's presumed to be innocent, listen to the evidence, and not have that prior experience alter anything you do in deciding what is going to happen in the case? All right. It's a very tall order. Similarly speaking, someone who's been incarcerated for any significant period of time is going to have been changed by that experience. And whether they feel, I served my time, you can serve yours, or I don't agree with the penal system at all, that is going to undermine fundamental fairness.
But there is avenues to take those people off, correct?
So as was described during the prior panel, during the voir dire process, it's a limited voir dire process that Senator Smith was inquiring about. There are a set number of questions, there's a set series of questions that are asked. They are geared at ferreting out bias for whatever might be of issue in the case. And based upon, it's voluntary, based upon the answers given by those individuals, they can or cannot be, we can make objections and say, Your Honor, we'd ask this person to be stricken, right? The judge can agree or disagree. And they can either seat that person or not. If the person uses the magic words, which are, I can be fair, regardless of what has been said, it creates a challenge where the court can say, all right, well, you use your strikes, right? In most misdemeanors, it's 4 and 4. As we stated, depending on the severity of the case, it can be 5 and 10 or 10 and 20, the state having the lesser number for the more serious cases. Once those strikes are gone, we're left at a disadvantage, right? And in terms of establishing a fair process for everyone, we will want to make sure that we don't have people put into the pool that are coming in carrying experiences that would color their ability to listen to this case objectively.
So you mentioned have a fair process. Is there data that shows that somebody who has been incarcerated for more than a year automatically has a negative bias? Is there any data that shows that?
So I don't have scholarly articles citing this. I would only state that it is logical that if one experiences something that is designed to change you, the penal system is designed to change the individuals it impacts, that it does in fact attain that goal, that there is some change that occurs within that person through that experience. That's the whole point of the penal system. The incarcerative system is designed to hopefully rehabilitate and change the people who are exposed to it.
Well, and that's why I'm looking at some form of data. If our goal is to rehabilitate people and we're not rehabilitating people, I could understand your objective. But if we are trying to rehabilitate people who have served their time, I just don't understand excluding them because we're concerned that they are going to have their life experiences impact this case. I say the word negative, but that's probably not the right way.
So it's
in a biased manner.
Yeah, it's similar to Maryland's laws that say because you committed a certain gun crime, you can never own a gun again, or because you've committed a sex offense, you have to be on a registry for the rest of your life. Right? There are laws that Maryland has that recognizes that certain lapses in judgment come with lasting impacts.
Well, and I concur that they should be there, but I'm not exactly sure that this pool of people who we're talking about rise to the level of sex offenders. I just don't know.
Or gun crimes.
Or gun crimes.
Okay.
Anyhow, thank you.
You're welcome. Thank you.
Senator Carter.
Thank you, Mr. Chair. It's a pleasure working with you, Mr. Chair. I think that my colleague, really hit on some pretty critical issues, but Mr. Gibson, you brought up the horrible situation of someone that's been traumatically or violently raped. And my question to you is, you brought that up to give an analogy to how certain situations are so horrible or so significant that you really don't overcome them. They shape you forever. And so we don't exclude categorically victims of crimes, correct? Including rape. We don't categorically say, oh, you've ever been raped, don't bother to show up for jury duty.
No, when we ask those questions of those individuals.
But you ask them questions is the point. They can come.
Yes.
All we're saying is we want these people to be able to come. And then you can have a chance to ask those questions.
So the distinguishing quality there is that the victim of a crime is the victim of a crime. They never made a choice to harm society. They never made a choice. They've lived in a law-abiding way and someone else acted against them. And I used rape, but
So your thing is more about, it's more about continuing punishment than it is about bias then. Is that correct?
No, they're two separate issues.
There's bias of the victim and then there's bias of the defendant. You're saying that the bias of the victim doesn't matter because they are the victim, but the potential bias of a defendant would matter because they made a choice to do that.
So there are two separate arguments. One, and you're correct, Senator Carter, in that they do intertwine. Argument one is that bias should be removed from the process. I stand by that, whether you're a victim or I would not seat someone who had been, if it's a case that revolved around burglary and someone had their house burglarized, equally traumatic to people's sense of peace and safety, not equally, but terribly traumatic to some individuals' sense of peace and safety. I would not put that person on my jury because that person would be carrying with them the baggage of their experience, which we're trying to avoid. So as to selecting a jury properly, a jury that's truly neutral, bias is always going to be an issue. However, there is a separate issue, which I am highlighting, which says that if you've exercised poor judgment and have engaged in crime, there's an argument that says, your judgment is flawed and you had a history of exercising poor judgment. And because of that, we're not going to allow you to exercise judgment over a person's life in terms of whether they're going to be sentenced to jail or not, or a victim's peace in the case where someone's been harmed in a significant way.
So I would take issue with the fact that a one-time potential exercise of poor judgment indicates a whole history of poor judgment, as you've just indicated. But that being said, I just want to bring up that you keep bringing up this idea of voir dire, which is important, critically important. Anybody can show up except for this group of people we've excluded. And so they show up, and one of the major questions in every courtroom I've been in is they ask anybody to stand that's ever been a victim of a crime. And then they go into one line, and then one by one, they come up and they're asked, about their crime and then they were victim of, and then can they be fair? And they say yes or no. If they say no, or even if there's a hesitation, the court will just let them go, dismiss them. If there's I've seen it, in my jurisdiction, my primary, but anyway, they'll be let go. So all we're saying is that when that one question is asked, you've ever been the victim of crime, stand up, come up, we'll ask you more questions. They can say the same thing. Ever been convicted of a crime? Come up, we'll ask you more questions, and then you're well within your rights to exclude any of those people for cause.
So they do that now, Senator Carter. And a couple of things. First off, what you're describing, I've tried cases for the last 20 years in 3 jurisdictions: Prince George's County, Baltimore City, and Howard County. Baltimore City, I've tried the bulk of my trial experience comes from the city. It very much depends on the judge. So the judge you're in front of really does drive the narrative of whether or not how voir dire is conducted is very much the judge is the conductor in that analogy. Like he or she is the person who is navigating that process. The person could come up and say, I've seen judges, if you answer any questions, exclude everybody. just, you answer the question at all, everyone gone, and then you just pick from what's left. The people who said nothing, right? There's one judge in particular that's done that in the city, right? I've seen judges go through the entire litany, and when they answer questions, there's some judges that kind of work extra hard to get them to say the magic words. And if they say they can be fair, then they rely on the state and defense to use up their strikes to remove them. I've seen judges that are very quick to use a challenge for cause and remove people who show a hint of bias. So it really is judge dispositive related to that process in picking a jury.
Thank you, but I don't want to sound like a broken record, but the issue that all the bill does is say that the group of people that have had a criminal conviction can show up and be called like everyone else, and that it's up to the court or the lawyers to make a decision. We don't want you here. We don't think you can be fair. But to categorically continue to exclude people is discriminatory. And I don't know how we incentivize people once they've served their debt to society, once they've served their sentence or their parole and their probation, and we still continue to say, but we aren't going to ever accept you again as a real citizen. I don't know how you reconcile that in terms of the fact that we want everybody to participate and be a good citizen. We don't have scarlet letters here. We don't say that once you've been convicted of something, you got to be ostracized and burned at the stake. We say that we expect you to come out, get a job, pay taxes, contribute to the tax base. And so do you not see the hypocrisy in making all of these demands and obligations on people, but still saying, but you're not a citizen though. We don't want to let you come into the courtroom unless you're in handcuffs. That's the only time we want you here.
No, I disagree with that characterization. So while I agree full citizenship involves the enjoyment of every right of citizenship, I don't think that excluding aspects of that full citizenship denies someone the ability to just participate in a positive way in their community after they've committed a crime, but in particular a crime involving a sentence of a year or more. Right. So I don't characterize it the way that you do. I'll put it that way.
So what about an administrative sanction? Like what about an officer that was removed from the force because of misconduct or excessive force? There was no criminal charge against that officer. We would not categorically exclude anyone for a civil finding or administrative finding of wrongdoing. Is that correct?
Correct. However, the fact that you described could have led to criminal charges. I've charged officers
It could have, but
Yes.
my point is there are all kinds of people. We don't exclude based on organization. So, the grand wizard of the KKK, for example, could be a part of a jury pool, and it's your job to weed them out potentially or not.
We ask a racial bias question.
But
yes.
we let them show up is the point.
Yeah.
Anyway, I don't want to. I could go on and on about the different people, organizations, types of people, biases, potential biases that we allow to show up. All this bill does is say, we are going to allow you to show up, but if you're biased, you're going to be, kicked out like anybody else that's biased.
And my argument is that I believe that someone with that particular experience, their bias would preclude them from producing a fair result when you're talking about exposing someone to that same, potentially that same experience, right? And again, the distinction I draw is that an individual who's been convicted of a crime has been convicted of a crime. And there are, as I stated earlier, certain offenses that Maryland wisely, in my opinion, has codified that say, hey, if you're convicted of these particular crimes, there are lasting consequences. You can never own another gun if you ever wear carry transport's a misdemeanor. Committed a gun crime, you can never have a gun again. I think it's wise. I agree with it completely. That is akin to this. There are certain lasting consequences to negative judgments, even if it's a one-time negative judgment where there's a judicial finding beyond a reasonable doubt that you committed this offense. There are lasting consequences to that.
You just don't want them in your trials. Is that correct?
I think if you're asking someone who's been incarcerated to potentially, and incarceration, by the way, the actual sentence is never supposed to be a factor that's weighed by a jury. Jury's never supposed to even know about that, ever. So if you're asking someone who's been incarcerated to decide whether someone else, based upon the facts and law in front of the case, should be incarcerated, I think that is an inherent problem.
That wasn't the question though, but thank you. I was talking, I asked you about, so the answer is yes? You would,
Yes, I'm
you would
talking
think
about,
they
I'm
could
talking about the
be
criminal context. My argument is,
invited to participate in civil, okay.
yes, my
thank you.
argument is with criminal context, Thank you.
I'm afraid to ask what I walked into. All right. All right. Senator West, we'll keep it moving.
This is a really short question, Mr. Gibson, maybe you can answer it. I'm not a criminal lawyer, I've never tried a criminal case. Why is it that the defense gets twice as many discretionary strikes when a felony case is coming up for a trial as the prosecution? What's the rationale for that?
So that's the framework that we have. I don't have a specific answer. My guess would be because the state bears the burden. So because we carry the burden of proving the case beyond a reasonable doubt, they have baked into the structure a disadvantage as it relates to selecting the juries. I don't know the history. I could research that for you, but I don't know the history beyond that.
Okay, thank you.
Further questions from the committee? All right, seeing none, that will conclude the testimony and the hearing for Senate Bill 34. Thank you all very much. Thank you, Senator Carter. Next, we'll hear from Senator West. Senator West will go with Senate Bill 75. Sure, we'll go, so belay that, we'll go with Senate Bill 164, Senator West.
Thank you, Mr. Chair, and members of the committee. It's a pleasure to be here. For three bills, let me set the stage for all three bills. So the Maryland State Bar Association has a number of substantive law committees. And on these substantive law committees, all the people in the state who practice law in that area are invited to become members of the substantive law committees. And then from all the members of the substantive law committees, some are selected to be on the section councils. Typically, they're the leading practitioners of practicing law in those areas. For example, I was on the business law section council for a number of years before I ran for House of Delegates back in 2014. When I was elected, I absented myself from the section council because I thought it might be a conflict of interest. So the Estates and Trusts section of the State Bar Association consists of lawyers in the state who practice almost entirely in the estates and trust area. And these are the leading practitioners. So from time to time, over the course of my career, both as a delegate and as a state senator, the substantive law sections of the State Bar Association have approached me and asked me to assist them in passing legislation which deals with technical issues in the law relating to that particular specialty in the law. And I've been happy to accommodate. Today, there are three bills before us, each of which is rather technical and tries to fix a problem in the existing Estates and Trusts article. These are not, I call these piffles because there's no opposition to these bills. And these bills will fix problems which will affect real people's lives, but they're technical problems. And therefore they're worth fixing, but they're never going to get headlines in the newspaper because the bills just aren't bills of that type. So let's start with the first one, which is Bill 164. This is entitled Estates and Trusts Interested Person Definition. So the first section of the Estates and Trusts article is a definitional section, and it defines the critical term interested person. An interested person in the Estates and Trusts context has the right to receive notification of anything that's happening in connection with the estate, and also has the right to come before the orphans court and be heard because that interested person is deemed to have a sufficient interest in the estate to allow that person to be heard by the orphans court. This definition has been in the Estates and article, I think, since the inception of the Estates and Trust article, and the term interested person appears repeatedly throughout the Estates and Trust article. So it's a critical definition. This year's bill is intended to clean up and clarify the definition of the term interested person. So, for example, currently in the definition of interested person is a legatee who has not been fully paid. This bill changes that definition slightly and clarifies that all legatees of the estate qualify as interested persons unless their interest in the estate has been fully paid or fully addeemed. Now, I'm not an expert in estates and trust law. That verb addeemed struck me as peculiar when I read it. The word ademption is estates and trusts lingo, meaning the receipt of property bequeathed to the legatee as distinct from money bequested to the legatee. So if someone says in his will or her will that a piece of jewelry will go to a certain person, that is, when it's turned over, that's referred to as an ademption. So we're revising the definition of a state interested person to include as an interested person someone who has a right to a piece of jewelry or some other article of personal property. For some reason, it has never been there before. So it's going to be there now if we pass this bill. In another respect, this bill states for the first time that an interested person includes a surviving spouse of the decedent who has timely filed an election to take an elective share, but makes clear that such a surviving spouse ceases to be an interested person if the election is withdrawn or ruled ineffective by the court. So for a period of time, someone who's taken elective share becomes an interested person. For some reason, the definition has never included that in the past. And finally, the other significant change to the definition is it now will include a person who has timely filed a caveat proceeding challenging the will of the decedent, but only until the caveat proceeding has been disposed of. Again, it's surprising to me that this has not been in the definition all these years. It should be, and this bill will make it part of the definition. Now, with that as a brief explanation of the bill, I'm happy that Roland Schrabler from the Estates and Trust section is with me. I always have someone from the section council of the estates of the section involved to explain or to answer questions which are more technical than I'm capable of answering. So I give you Mr. Schrabler, and then we'll together try to answer your questions. Mr. Schrabler can tell you what a caveat proceeding is.
Good afternoon, Chairman Smith and members of the committee. I'd like to keep my testimony brief. I believe that Senator West will not mind if I make a small correction to his explanation. A ademption is when someone leaves something specific to a beneficiary, but at death doesn't own that specific thing anymore. An example would be, I leave my BMW to Mr. Schrabler, but then the decedent dies and doesn't own a BMW. So now I no longer have an interest in the estate. And just to keep this very simple, what this bill intends to do is to change the definition or revise the definition of interested person so that someone who has a economic interest in the estate has the right to challenge certain things. But if someone no longer has an economic interest in the estate, they no longer have the right to challenge certain aspects of the estate. Person doesn't own a BMW at death. Why should I be able to challenge who's appointed as personal representative? I have no economic interest anymore. Thank you. The Estates and Trust Section Council would request a favorable report on this bill.
Just a really simple question. I'm going to support the bill. Makes complete sense, but I'm just curious, how have you eked along all these years? With, I mean, you know, I'm like, okay, so my mother left me a BMW. Darn it, she didn't own it when she died. So what was I before? And what would I have done before? Just short answer. I just want to know because I don't know, right? Yeah.
You would have the right to challenge certain aspects of the administration. For example, who was appointed as personal representative? Why wasn't that in there before? I can't really answer that. I've been practicing 30 years, but I don't know how this was
Have you
first
seen,
arrived.
I'm just curious, I mean, have you seen people that would be a legatee, but they're not because they don't, there's no property. So at some point that'll get sorted out by the court. They're named in the will, obviously, or, you know, have you seen that
Yes.
where somebody's creating mischief, if you will, with the
Yes,
state?
this arose originally because a practitioner came to us and said, a court allowed this challenge to who's appointed as personal representative, but I don't think that's right. And so we looked at that specific situation, and then going through the definitions, we said, oh, we think there's also these other situations that should be clarified. And so then we clarified those other situations.
Very good. Thank you.
All right, see, no further questions from the committee. Thank you very much, Mr. Schrabler and Senator West. Actually, do you want to move on? Which one do you want to go to?
How about Senate Bill 80?
All right, we'll now hear from Senator West, Senate Bill 80.
Thank you. I won't give my long introduction about the Estates and Trust section again. So Senate Bill 80 sort of follows on to the bill we just heard. Under current law, any person can file an objection to the appointment of a personal representative of a decedent. Any person. That's what the law says. So Senate Bill 80 says, amend section 7103B of the Estates and Trust article so as to only allow an interested person to, or an unpaid claimant against the estate to file objections to the appointment of a personal representative. So that's why I took this bill second. You now know what the definition of interested person is. So this bill, Senate Bill 80, says any person doesn't have the right. It's only an interested person who has the right to file objections to the appointment of a personal representative. It's a very simple bill, and I give you Mr. Schraber to discuss the bill further.
Thank you, Senator West. This bill specifically, if you are named in the will, the BMW, but doesn't own the BMW anymore, for example, you receive from the Register of Wills office a notice telling you, you can see the text that we haven't changed and the estate has been opened. Here's the situation. And we said, people who receive this notice, like the person who isn't going to get the unowned BMW, should be made more aware, or should be clearly made aware of what they can do and what they can't do. And so the middle paragraph split out, okay, if you're an interested person, you can do this, you can object to the personal representative. If you are not an interested person, you know, you can say the real will is this, but you can't object, for example, to the appointment of a personal representative. So States and Trust Section Council, again, would like a favorable report on this bill.
Seeing no further questions from the committee, thank you all very much. That'll conclude the hearing for Senate Bill 80. Continue building the blocks. We'll now hear from Senator West to Senate Bill 75.
Thank you, Mr. Chairman. Senate Bill 75 is another one of these technical bills. So here's the situation. A decedent dies and leaves a bequest to a minor, but the will doesn't provide that the personal representative administering the estate has the right, has the authority to set up a custodian for the benefit of the minor account and transfer the bequest into the hands either of an individual or a trust company acting as the custodian for the benefit of the minor. That's the way it ought to happen. You don't want to give a substantial amount of money to a 8-year-old. So you turn it over to an adult who is appointed the custodian for the benefit of the minor, or to a trust company for the custodian of the minor. So the current version of section 1330-306 of the Estates and Trust article says that can happen even though there's no provision in the will to permit it to happen, so long as the bequest is for $10,000 or less. That has been now the law for 35 years. No change has been made in the past 35 years. Everything has gone up. Inflation has occurred. And so the suggestion of the Estates and Trust section is we really need to increase this amount of money. They wanted to take it to $50,000. That's what's in the bill. I've talked to people from the orphans courts who think 50,000 is too high. They suggested a compromise number of 25,000. I think you're going to find an amendment in your packets, changing the 50,000 in the bill to 25. We're entirely amenable to that. You don't want it to get too high because we're talking about a lot of money here, and anything over 20,000 is a significant amount. The orphans court ought to have some control beyond the $25,000 level. So if the money gets turned over to someone as custodian for the minor child, and that someone deals inequitably with the money, fritters the money away, takes the money, the orphans court has control over it. So 10,000 is too low. Apparently 50,000 is too high. The recommendation is to increase the $10,000 number to $25,000. And with that's the sole purpose of this bill. And with that, once again, I give you Mr. Schreiber.
Thank you again, Senator West. In 1989, when this was passed, the legislature decided if it's 10,000 or less, then it can be paid to a custodian, which is a lower level of scrutiny. If it's above that, it needs to be paid to a guardian who is under continued court supervision, annual accountings. That was 1989. Now it's 2024. And logically, the threshold for concern and for greater supervision should also have increased. And we are asking that this be in line with neighboring jurisdictions. If you adjusted for inflation since 1989, you'd be roughly at $25,000. So for all those reasons, again, the Estates and Trust Section Council requests that this committee issue a favorable report.
Just really quickly, so initially I thought, upon description, I thought it was that this is the amount that someone could be paid without like additional scrutiny to administer the trust, but this is the amount of money that can be taken out of the trust and given to the minor without, tell me.
No, I'm sorry, perhaps I was unclear.
No, yeah.
If it's 10,000 or less, it's paid to a custodian.
Got it.
Who can decide this is a good expenditure for the minor, or this is not a good expenditure for the minor, but that custodian is not under continued supervision. So they're more free. It was 10,000. Now we would like that raised to 25,000. Thank you.
Thanks. Thank you. The only other thing I would say is, just so we're not coming back here in 30 years or 10 years or 5 years, have you thought of any sort of a formula that automatically, like an escalator formula or something? I don't know.
We did think about that. We thought that doing that, although we would personally be in favor of it, creates a situation where someone, whether it's the orphans court or the trustee or the personal representative or whatever, is going to have to do a more complicated calculation. All right, what's the rate of inflation each year since then? So what's the amount today?
Fair enough.
Thank you.
All right. Seeing no further questions from the committee, Yes,
Mr.
Senator
Chair,
West,
if
yes.
passes prologue to the future, it'll be 35 years before they come back. and increase the
Yeah,
number again.
that'll be someone else's problem by there. Right. I won't, maybe you'll be here, I won't be here. All right, with that, that'll end the hearing for Senate Bill 75. Thank you, Senator West, and thank you, committee. See you tomorrow.